but not least, I would like to introduce you to Jonathan Chamberlain, a partner at Goling WLG, our English member firm. He is located in London. Jonathan practices employment law, where he has a particular focus on business protection. Recent cases have involved safeguarding clients' confidential information in Formula One racing and high-value consumer goods, as well as dealing with team moves in financial services. And my name is Philipp Dickenmann. I'm a partner at CMS Switzerland, and I'm based in Zurich. My core practice are dispute resolution and commercial work. I'm also a co-head of the World Law Dispute Resolution Group. And in addition, I head the CMS Dispute Resolution Department in Zurich. Now, let us start with our topic, the protection of trade secrets when it comes to dispute resolution. My first question is, when a company becomes a party to dispute resolution proceeding, is there an automatic protection for trade secrets, or is it necessary to apply for protection? And how is such application made? And what protection is available? And for what kind of trade secrets? I would like Indran to start with the situation in Malaysia.
Thank you, Philip. And may I just wish everyone good morning, good afternoon, good evening, good night, depending on where your time zone is. As a general rule, and I think maybe I shall distinguish between how trade secrets are dealt with in the civil courts as well as alternative dispute resolution, since that's the subject matter of the topic. Now, in the civil courts, there's no automatic protection for trade secrets. And as a general rule, all documents that are relevant and witnesses which would be able to provide evidence in a particular case would have to come and give, the evidence has to be produced, and the witnesses are compellable to give evidence as well. The only issue is whether they're relevant or not. So what happens to a trade secret then? Would it be automatically protected? The answer is no. And how do you go about then protecting that trade secret in a civil litigation setup in the civil courts? You would have to apply for a protection order or a sealing order. And before that can be done, you would have to persuade the judge that the information or the documents or the witness testimony has the necessary elements of being a trade secret or confidential information. There's general principles here that will apply. Essentially, the information must be confidential in nature, in that it's not in the public domain. Secondly, the information was imparted in an occasion of confidence, which is usually would arise in an employer-employee kind of setup, for an example. And if the information is disclosed, it will result in damage to the person whose trade secret it is. So you need to persuade the judge that you're applying for the protective order, that the trade secret or the information that you're seeking to protect has these necessary ingredients. And then what the court would do is they would conduct a balancing exercise to determine whether the information should be kept secret, or would it be in the interest of justice to prevent its disclosure? Because at the end of the day, the court has to make a determination on the merits of a particular case. And if the trade secret or information is necessary for that, then the court will have to then balance those conflicting interests and then decide whether to admit the trade secret or not. A middle ground would be the protective order, where the court will then say that the information could be released under limited circumstances, in the sense that it will be released to just the parties or their respective counsels or certain expert witnesses, and not necessarily to the general public. The proceedings may be held in camera, and if there are documents, and generally documents that are tendered in court are publicly available. So what the court could do is also impose a sealing order on the document to ensure that the public would not have access to those documents. So in the court setup, in the civil court setup, there's no automatic protection. You'd have to go to a judge and persuade the judge, with proving that the information has all the necessary ingredients, and then the court performs a balancing exercise and then either imposes a protective order or sealing order. Now that happens in the civil courts. Now what happens in alternative dispute resolution? Now alternative dispute resolution is largely dependent on how the parties can agree to the manner in which the dispute is resolved, and sometimes the parties can make arrangements before they refer the matter to alternative dispute resolution as to how to keep the documents confidential. Now, in Malaysia, we also have an arbitration act. So if the proceedings goes via a dispute resolution which is governed by the arbitration act, there's a general provision of confidentiality where both parties need to maintain confidentiality of all documents that are tendered and all evidence that are tendered during the course of an alternative dispute resolution. It's important to stress here that that may not apply to third parties who are not parties to the proceedings. So again, there's no automatic confidentiality even for alternative dispute resolution, and it will be subject to the parties trying to ensure that the information is kept confidential.
Thank you much, Indran. Now we move to Germany. Julia.
Okay, thank you, Philip. It's a pleasure to talk to you all and see that we have so many of our members in the audience, and I hope it's interesting for them. Let me tell about the situation, especially in Germany, but also in Europe. There is, like in Malaysia, no automatic protection of trade secrets. Usually everything has to be published to the parties which might be of importance to decide the case. But different than the situation in Malaysia, it depends on what can be done, whether the proceedings are state court proceedings or they are arbitration proceedings, and in case there are state court proceedings, it has to be distinguished whether the claim is based on the German Trade Secret Act or it is based on other laws. State court proceedings based on the German Trade Secret Act. Here, the situation should be very similar in all European countries, as the German Trade Secrets Act is based on a European directive. Only at the request of one of the parties, the court may classify information in dispute in whole or in part confidential. If such a classification is made, the parties, their counsel, witnesses, experts, and other representatives, and all other persons involved in the trade secrets proceedings, or having access to the documents, must keep them confidential and may not use or disclose such information outside of the proceedings. If classified by the court as confidential, third parties who have the right to access to the court files will only get documents in which the trade secrets have been made unrecognizable. Further, the court may, at the request of a party, restrict access in the whole or in part to a certain number of reliable persons, to the documents submitted or produced, to the oral hearings, and to the recording of the minutes, to the recording or the minutes of the hearing. This applies only to the extent that after weighing all arguments, the interests to protect the trade secrets are overweighing all other interests, especially those of the parties to get to know everything. This also is true for preliminary injunction. In case a claim is not based on the Trade Secrets Act, that means is the question in dispute is not a claim regarding the unlawful obtaining or disclosure of a trade secret, but for example, it's a claim of an employee against his employer as of not paying his salary. The following measures are available. There are only very few measures. The court may exclude the public from the oral hearing or from parts thereof if an important secret is raised and the public disclosure would harm overriding interests worthy of protection. The measures can be taken other than in trade secrets proceedings on request of a party or ex officio at the court's discretion. In the arbitration proceedings, I think there's no difference between the European situation. It depends on the rules of the respective arbitration board. And I think it's the most easiest, the WIPO arbitration. So everything shall be in private anyhow, and every other is decided between the parties and the arbitration court. So I think that's the main aspects under German and also under European law.
Thank you.